Good afternoon. Welcome to the House Criminal Justice Committee for Wednesday, January the 26th. Madam Clerk, please call the roll.
Representatives Beck, Campbell, Dixie, Doggett, Farmer, Griffey, Hardaway, Hawk, Howell, Halsey, Lamar, Lamberth, Moody, Russell, Sherrill, Vice Chairman Sexton, Chairman Curcio.
Here.
Mr. Chairman, you have a quorum.
Thank you very much. Members, as we announced last week, today we have some pretty important duties to dispense with. We have a nominee that has been presented to us from the governor. Representative Dixie, you wish to be recognized? Oh, I apologize. I forgot the personal orders segment. So, Representative Dixie, you're recognized.
All right, thank you. I just didn't want to get involved to get way down in the weeds and the real stuff happens. But I just wanted to recognize my intern. I know everyone has interns here, but I know I have the best one, and they saved the best one for me. Her name is Kamora Reeves, and she's a Tennessee State University student. And she's very bright, and she'll be coming around to introduce herself to each one of you. And if she doesn't, please let me know. Thank you.
Very good. And I apologize, members. Any other personal orders? Chairman Farmer, you recognized.
Yeah, thank you, Mr. Chairman and committee members. I also have the Civil Justice Committee intern here today, Mac. Mac, if you stand up, just make him welcome. So if you see him around, point him in the right direction. Glad to have him here. Thank you.
Next, I have Leader Lamberth.
Thank you, Mr. Chairman, and we appear to have started something that may go on for a bit. There's a lot of really good interns in the audience today, including Lucas Perry. And for all you interns that are not in our office, Lucas has had to endure being given a blue book and then being asked, like, what's the state flower, what's the state animal, all that kind of stuff. And I'm going to give him credit. He has yet to miss one. So members, not on the record here, but as you see Lucas anytime today, ask him any of that stuff out of the blue book, and he's already got it memorized. He has it down pat. So Lucas Perry, best intern in the building. We appreciate you, Lucas.
Wow. Okay. Representative Griffey, you recognized.
Thank you, Mr. Chairman. I just wanted to recognize my friend Mike Donovan, the former U.S. Attorney for the Western District of Tennessee, who's now with the Comptroller's Office, and appreciate him being here in front of the Criminal Committee, full committee.
Thank you for being here, sir. Representative Hardaway.
Thank you, Mr. Chairman. Lucas, you're on the spot. What's my name? What's my district?
We didn't test
Welcome, Lucas.
Lucas, you're not recognized. You don't have to answer that question. Next on the list, I have Chairman Moody. You're recognized, ma'am.
I would also like to recognize my constituent, Mike Donovan.
That's right. Any others? Okay. Representative Hardaway, you're recognized again.
Thank you, Mr. Chairman. I'm trying to remember what city that Mike Donovan was in when he was in the U.S. Attorney's office. I think it might have been, was it Memphis? Ah, okay. That trumps all the rest of you.
Everybody's claiming him today. All right. Okay, seeing none others, as I mentioned before, we do have some important business ahead of us today, as we announced last week. We do have a nominee before the committee for the Criminal Court of Appeals, and that is Judge John Wheeler Campbell, Sr. He's currently a criminal court judge in Division 6 and has held that position since 2012. I know many of you have had an opportunity to visit with Judge Campbell, and today we'll have an opportunity to hear more and also to ask some questions. But I want to briefly explain why we're here, because I get this question a lot. I'll even have folks from my district call and say, now help me understand, why this process is happening. So a constitutional amendment proposing the judicial confirmation process was approved by the voters of the state on November the 4th, 2014. The procedures governing the process were passed into law by the General Assembly on January the 28th, 2016. And when a vacancy occurs, the governor appoints a nominee to fill the vacancy, subject to a vote of both chambers of the General Assembly. The roles of the Criminal Justice Committee of the House of Representatives and the Judiciary Committee of the Senate are to hold hearings on the nominee and to provide a recommendation either for confirmation of the nominee or rejection of the nominee to their respective bodies. And so today, I want to give everybody a sense of how we'll go through this. I want everybody to know they'll have an opportunity to ask questions, but the governor's chief counsel will introduce the nominee to the committee. The nominee will make his opening statement, and then I will open the floor to the committee members for questions, and then following questions, I will entertain a motion for either recommendation for confirmation or recommendation for rejection of the nominee. So does everybody understand that? Any questions? All right, seeing none, then we are going to gavel out of session. The committee is now out of session, and Jonathan Skrmetti, Governor's Chief Legal Counsel, will come forward and introduce the nominee. And sir, you're well known to this committee, but if you wouldn't mind, please state your name for the record.
Thank you, Mr. Chairman. Jonathan Skrmetti, Chief Legal Counsel to the Governor. It is a privilege to be here to introduce you to Judge John Campbell. He's had a distinguished career in criminal law. He spent his entire career in criminal law and his entire life in the city of Memphis. He went to U of M both as an undergraduate and a law student. He worked for a year at the Shelby County Public Defender's Office, and then he spent a long and distinguished career at the Shelby County District Attorney's Office. He handled some of the most major cases in that office, including perhaps most notably the post-conviction litigation involving James Earl Ray. He was ultimately the Deputy District Attorney General in that office before being appointed to the criminal court bench by Governor Haslam. He was elected in 2014, has spent nearly a decade as a criminal court judge, earning a stellar reputation in Shelby County and across the state. He serves as the chairman of the Trial Judges Education Committee, and it is my privilege to present him to you as the governor's nominee for the Court of Criminal Appeals. Thank you.
Thank you, sir. And Judge Campbell, you can stay seated or you can stand at the podium, whichever you're more comfortable.
I think I'd rather stand.
Very good, very good. I understand. If you could just state your name for the record and then share with this committee your statement.
I'm John Campbell. I am the currently sitting judge, Criminal Court Division 6 in Shelby County. I do want to recognize my wife is here to watch these festivities, Debbie Campbell. We've been married for 40 years, and 40 years is as long as I've been at the Criminal Justice Center in Memphis. I started as a law clerk for Judge Axley, who I'm now in his seat, in 1982. And I never left the building. I've just changed floors during my career. So it's very few people can say that, but I've been at 201 Poplar since it opened and watch it go from orange carpeting to green carpeting to what we have now. But it's been a great experience for me. And I know people talk about criminal law, and a lot of attorneys, I know several of y'all are attorneys, sometimes people look down on criminal law. And we're very fortunate that our criminal bar gets along very well. We have a very good relationship, and it's been a pleasure being an attorney and being a judge in Memphis. I've enjoyed every minute of it. I have general jurisdiction now. I've handled everything from DUIs to capital murder. I have been a teacher. I've taught trial advocacy since the mid-90s. I teach judicial ethics now, and I also teach a number of areas for the judges, as well as set up education for the judges. I take it very seriously. And like I said, I've enjoyed every minute of it. I'm open to any questions y'all may have, and hopefully I can show you that I'm a good pick for this position.
Thank you very much, sir, and we appreciate your remarks, and that's amazing. You've been at 201 Poplar since they opened, and I have it on good authority, though, that the real secret here is that I understand maybe your wife maybe helped put you through law school. Is that correct?
She at least kept me from losing my mind, so I guess that's a good thing. But she's also, I mean, and I mean this, there's a lot of times when you're going through a career and you have thoughts about, well, am I doing the right thing or not? And she's always been there to kind of keep encouraging me when sometimes you think, like, does this really make any difference? Am I really doing the right thing? And she's always been there to kind of keep me moving in the right direction, I think. And I really feel like this has been a joint effort to get to this point. So I really appreciate that, and I mean that sincerely.
Excellent. Well, thank you for being here today, and thank you to your wife as well for being here and making the trek. I wanted to just start us off by, it would seem unusual to undertake a judicial confirmation hearing without mentioning, of course, the major news of the day, which is at the federal level. where we have a Supreme Court justice who's announced their retirement. And I always want to take the time to talk about how Tennessee leads. And we've been very fortunate since this process was established by law in that, these confirmation hearings are not referendum on, political vendettas or other agendas. And I'm very proud of that in Tennessee, we want to know that we've got thoughtful attorneys who become judges who will interpret the law and follow the Constitution. And so I wanted to start us off by just talking about that a little bit. And maybe if the question would be, have you found yourself in a situation where you were conflicted, where maybe your personal beliefs didn't line up with the law and the Constitution, but at the end of the day, the way you would decide a case like that, personal belief versus following the law and the Constitution?
Well, I wouldn't say it happens very often. There's a few times, and I think it has to do sometimes with sentencing considerations, when you have something that is a mandatory thing and you're looking at it, you're thinking, this is just a little more than I think it deserves. But if the law sets out this scheme, and I tell jurors every time, when I have a jury come in and I'm talking to them before they start, the one thing I emphasize is that in order to have equal justice under the law has to be applied equally to everybody. If you start making exceptions and saying, that guy, I just feel sorry for him, it's not equal anymore, because then it becomes a crapshoot about who happens to be on that particular jury at that particular time. The only way we can have equal justice is if we apply the law equally, regardless of who you are or what you are or anything else. And that's what keeps us equal. And I tell the jury, what you do is going to be justice in this case. And we want to make sure at the end of the day that justice is served. So in some ways, it's the easiest thing in the world, follow the law. And that way, if you follow the law, then you're not going to get yourself in trouble because, like I said, you're applying it equally and you are the result is going to be sustainable, it's going to be defendable, or you can defend it. And I just think that's the most important thing about our system. And when you're talking about the way Tennessee does it, I've gone through this process 3 times. I applied in 2007. I made the 3. I didn't make the selection Judge Folks did in Division 6, and he went on the federal bench, and then I applied again, and I got picked. But what you have to go through for this process is you have to open yourself up to all kinds of an investigation. TBI has to investigate you. Your finances get investigated. Everything that you've done in your past, bar complaints, cases you were involved in, all that stuff gets scrutinized. And so at the end of the day, you have a public hearing, and some of that, they ask you, well, what happened here? Why did this happen to you? And so you have to lay yourself open. And then at the end of the day, 3 people's names come out that the committee says, these are the best folks based on their character, based on their experience. These people are the best choice for this job. And then the governor makes his selection. So, and to me, that is a really superior system in picking a judge. It's not just chance in an election. It's not just, it requires a thoughtful consideration about who that person is and is that person the correct person for this particular job. So I feel like even though some of it is not pleasant to go through, trying to dig up old transcripts and all this stuff that you have to find, but I think in the long run it is really a good system. So I think Tennessee does it right in that regard.
Great. Thank you for that response.
Sure.
Another thing that I've occurred to me is you're going from a trial court unto now this appellate court. Mm-hmm. You're sort of the quarterback in the trial court, right? The buck stops with you unless, of course, something gets appealed after you've ruled. Have you thought about the dynamic working with 2 other judges? And we've been very fortunate. I don't think we've seen at the appellate level the sort of my way or the highway mentality. I think it's more of a collaborative effort of 3 very intelligent, well-qualified people coming together and being able to make a decision together. Have you thought about that dynamic, that shift?
I have, and again, fortunately in Tennessee, and I know all the judges on the Court of Criminal Appeals. I know them, I like them. Everybody gets along, and I think the word you said was consensus. There's really an attempt to find a consensus among the 3 judges. The difference between the trial bench, which I love being a trial judge. I really do. I'm not looking for another job because I don't like the one I have. I love my job. but it's a completely different environment. You're case managing more than anything. You're dealing with the public, you're dealing with lawyers, you're dealing with chaos most of the time with all the stuff that comes in. I handle about 1,300 cases a year as it is now. I dispose of about 1,300 cases a year. So there's a lot of stuff going on, plus you have trials and you got to deal with that. Everything happens pretty quickly, and very rarely do you have an opportunity to come just sit and think about, okay, what about this? You have to kind of make, a lot of times, spur-of-the-moment rulings. And a lot of it based on your experience, and for the most part, I think the judges generally get it right. Very few cases get reversed because a judge has made a really bad, boneheaded decision. Most of the reversals we get in Tennessee, a lot of times come out of jury instruction issues or things like that, that a lot of people, even me, have questions about sometimes about, is this a lesser and all that? But be that as it may, you have to make a lot of decisions quickly. The Court of Criminal Appeals is a whole different environment. First of all, your whole world has already been created for you. The facts are already been established. The issues are already there. So you're going to be looking at, okay, these are the facts I have to work with. These are the legal principles. What do I think about what happened? And you have 3 judges you can bounce, or 2 other judges you can bounce things off of. You've got the luxury of being able to sit back and think about it and analyze it. And in the end of the day, you're going to come up with an opinion that either says this was perfectly right or this was not right, and here's why it wasn't right. And what you're going to wind up doing is setting out, hopefully in very clear terms, this is the way you should do things, and in the future, make sure these things are done. So you're educating the lower court. But you have that opportunity to be able to digest it and flesh it out in a way that down the road people can say, okay, this is the law in Tennessee, this is how I'm supposed to do this. And I think that is what the Court of Criminal Appeals job is. We're an error-correcting court, and I think we're there to educate the trial judges about, this is the way it should be done, or this is the way it shouldn't be done, but give them solutions in clear terms. And then if there's an issue that we feel like we need to do something about in Tennessee, you couch it in a way that the Supreme Court will maybe take it up and say, okay, we need to make a final determination on this.
Excellent. Well, thank you very much for responding to those. Members, I think you've just heard between those 2 answers a pretty textbook description of what this job entails, and I think we've got an excellent candidate here before us, but certainly want to open it up to the committee for questions to the extent that anyone has any. I'll get you on my list and make sure we get to you. And that list has already started, and I'll start with Chairman Hawk. You're recognized, sir.
Thank you, Mr. Chairman. Judge Campbell, very nice to meet you today.
Yes, sir.
Most recently. And I'm piqued by part of the answer that you gave just a moment ago, educating our trial court judges. And I would encourage you, and this has been done previously, where our regional criminal courts of appeal will go into communities to have session on occasion. And I'll use specifically in Greenville.
Right.
We met at the Performing Arts Center and invited students and other attorneys and other courts from all the East region to come in. And I would encourage you to continue that, as I heard that you've practiced your whole career in one building, to go outside those buildings. And what are your thoughts on that and taking the Court of Appeals into communities so we can all see?
I think, and when I was being examined by the council before my name came out to the governor, one of the things we talked about was, what is the purpose of the Court of Criminal Appeals? And part of it is and I said is for transparency. It is to give the public confidence that the decisions that are being made in criminal courts are in fact legal and valid. And so our job as the Court of Criminal Appeals is to review these and make sure that they are legitimate decisions that can be defended, and give the public confidence. The Scales Project, which you're talking about, I think does that. And I've actually been to Scales hearing in Memphis. I wanted to watch a proceeding on a case that I was involved in as a prosecutor, so I went and watched the argument with the Supreme Court. So I think it's a great thing. I really do, and I would be more than happy to engage in that. I think it is a great thing to do, and I think the public, a lot of times when they kind of see what really happens, I invite people all the time to come down to criminal court to see what it really is like and not television. This isn't TV, and people are fascinated by when they actually see the actual proceedings. It's nothing like they expected. My jurors are always like, man, we didn't know it was like this at all. A lot of them are like, I have them want to volunteer to go again. They enjoyed it so much. So I think it takes the mystery out of it, and I think it also, they can hear that, these people are pretty smart. I mean, these people who are making these arguments and they hear how the arguments develop, I think it gives them a different view of the legal system.
Thank you, Chairman Hawk. Next on my list, I have Leader Lamberth. You recognize, sir?
Thank you, Mr. Chairman, and Your Honor, more a statement than a question, really. I just appreciate you putting your name forth, and you and I have served on different committees together, and I've known you for quite some time now, and I've known you to be a very thoughtful jurist. I know that you have experience both as an assistant public defender, but primarily as an assistant district attorney, but in just our conversations, it has always come across to me that you genuinely look at the individuals that are coming to your courtroom and see the humanity of each and every person that is before you. And to me, that is one of the most critical roles that a judge can have. That, and as you've said, reading the law exactly as it is written. And it is amongst my colleagues here that the law should be written. We speak as the voice of the people on how the words on the page should be designed. And then we only ask that you really interpret, but beyond interpret, when possible, just apply those laws exactly as they're written. And I know just from our conversations that that's exactly what you've done on the bench for a long time. Mm-hmm. And so I just wanted to say thank you, and I certainly support your move to the Court of Criminal Appeals. The only thing that I will say is I think your community is definitely going to be at a loss without you there on the bench, because you've just done so many programs that you and I have talked about that have helped out those folks that are coming through your courtroom. So I hope and pray that there is someone that's able to fill your shoes there and fill your robe there that will still see the humanity in each individual that comes before you. So thank you for your service, sir, and again, thank you for putting yourself forward for this position.
I appreciate that, and one thing I will say, talking about the letter of the law, and I talk about this a lot because people don't understand the sentencing laws in Tennessee very well. But our sentencing laws are individualized sentencing. And I emphasize the fact that you may have two people who commit the same offense, but they're two completely different things. And the way our sentencing laws are drafted, the way you all have drafted them, makes it imperative for the judge to consider the individual. And all these factors we have to consider. So no two sentences are the same, and they shouldn't be. We shouldn't have, we had a Chinese delegation come in, Communist Chinese, and we're going to use computers to determine sentence. It's all going to be number crunching. And I thought, that is the most totalitarian thing I've ever heard. You take away the factor, the factor of the judge considering, things other than just what's written on a page. You give me so much discretion in sentencing. And I believe, the mandate is, you have to consider alternatives before you consider incarceration, and you should consider the least amount of incarceration necessary to effectuate the results. So those are all those things that, puts it on me to make me creative as a judge and creative in sentencing. And I deal with a lot of drug cases. That's mostly what I'm dealing with. And so we're always looking at alternatives and treatment programs that are available. And y'all have done a really good job about expanding the day reporting program with the Department of Correction. It is a fabulous program. I will tell you right now, when y'all are considering expanding it, it is a lifesaver. And we keep it pretty full in Shelby County. And it's my last resort sometimes for folks who've been through other programs. They really help them out. There's a drug component. There's a component for job skills and education. I mean, it's a really good program. So again, thanks to y'all, we have individualized sentencing, and the judges are given a lot of discretion in how to try to solve some of the problems.
Excellent. Thank you for that feedback. Next on my list, I have Chairman Holsey. You recognize, sir.
Thank you, Mr. Chairman. Thank you, Judge.
Sure.
I got a lawyer in front of me. It's not the first time he's gotten my way, so I'll lean around here a little bit. Thank you. This doesn't have so much to do with where you're going, but now you could be candid about where you've been. And when I was in the police department, when I first hired on, there might be 3 cases on a docket in Sessions Court. When I left, there's 21 pages. And the same thing in criminal court as well. Looking back, what do you think is the top 2 or 3 reasons why criminal courts are so clogged and backlogged, and why it takes over 2 years sometimes to hear a case, with people in jail for a lot of them are, with no bond in that time frame? And is there anything we can do about it here?
Okay. I kept, we were cleaning my office up the other day. I have framed my docket the first day I was on the job in criminal court as a prosecutor from 1985. There's like 25 cases on it. And at that time, that division was considered out of control, had too many cases. I probably have 1,500 cases pending right now. I mean, it's nuts when you start looking at it. But if you start looking at what it is and what's going on, huge number of drug cases. I mean, drug cases and property offenses are pretty common. But in Shelby County, the thing that I see is we have individuals who commit a bunch of robberies. I mean, I've got a group now, I've got 5 people that have 35 cases amongst themselves. They take up a whole day. Bunches of carjacking. They do all these carjacking cases. They get delayed because the federal government is looking at prosecuting 1 or 2 of them in the federal court, which slows everything down. I mean, it just does. And I wish I could speed it up, but I can't. Most of the cases we have are disposed of within about 90 days. Most of the cases I have, 90 days with the drug cases. The murder cases take longer because the pretrial is so much more involved. There's a lot of times there's mental evaluations that are being done. It takes sometimes 3 months to get someone just seen by a doctor, okay? 3 months you can't do anything. I can't have a hearing on the case until I get a order back or a letter back saying this person is competent to proceed. So that delays it. Then it's just, and I hate to say it, when you start having things like body cam, I mean, when body cam came in, body cam. A murder case, and you have 15 officers show up at a scene. Each one has a body cam. Each car has 2. And all those get uploaded. The minute they get back to the station, they're automatically uploaded. And then you have to review those. It takes a long time for that stuff to be reviewed. So we kind of have a built-in lag. I mean, if I can get a murder case tried within a year, that's great. Most of the time, it's 2 years. And now we've lost 20 months because of COVID. In Shelby County, our health department wouldn't let us try anything because our courtrooms were too small. So we then didn't get to start trying cases again until the summer. So July was when we first started trying cases again. So from March of 20 to July of 21, we didn't try anything. And all that stuff got backed up. So, but the number, I mean, Memphis had 342 murders last year. I mean, the worst year I ever had when I was a prosecutor was in 1991, during the height of the crack epidemic, when the crime rate was actually much worse than now. And we had 219, and that was the record. In 3 years, we've gone to 230, 340, and now 340. I think 346 was this year. I mean, and then if you want to include fentanyl deaths and opioid deaths, I think they had 600 in Memphis last year. And those are all murder twos. They're not counted. And then our police department's smaller. I mean, our police department's 500 officers down. And it's just a perfect storm. And so we try to move what we can. And most of the cases, I think we move pretty rapidly, I think, under the circumstances. But there's going to be about 25% that you're going to be living with for a while. And that's just the fact of life. But, yeah, we've gone from, having maybe 1,000 cases per judge to 1,500 to 1,800 a judge. And I don't really know if there's anything you can do about that. I'm afraid that we're just going to have to work through it. Yeah.
Chairman Helsley, any further questions? Okay. Next on my list, I have Representative Hardaway. You're recognized, sir.
Thank you, Mr. Chairman. Good afternoon, Your Honor.
Yes, sir.
And you tell me if I have this correct. You served as a assistant public defender in '84?
Started in '84 until November of '85.
Okay. And that was a pretty brief stint. You left there and went to the prosecutor's office?
Right. When I started out as a clerk, I was a law clerk for the judges in law school. And then when I passed the bar, there was an opening in the DA's office, and there was an opening in the PD's office. The DA's office was in general sessions as an investigator. The prosecutor's office, I mean, the PD's office was a trial assistant in criminal court. And so they offered me the job, and I took it because I wanted to get trial experience. And I had a great experience. The PD's office in Memphis, I had a great time, great people I work with. And then in September, I took the job in July of 84, and then in September of 85, there was an opening in the DA's office, and they asked me if I was interested. And I thought about it, but I thought, and even I was talking to A.C. Wharton at the time, who was my boss, and he said, look, I can't pay you what they pay you over there. So he said, I understand. And at that time, the DA was a former PD. Hugh Stanton was a PD, and then he became the DA. He was elected DA. And so a lot of PDs were being hired by Hugh Stanton, so he hired me. And again, I thought it was I made a great choice. I enjoyed the PD's office, but I've really enjoyed the DA's office, and I made it a career. I was there for 27 years.
Tell us how each of those experiences have shaped your philosophy as a judge.
First of all, and I think this is the one that, and I've talked to other judges about this, being a defense attorney, being a public defender, which in some cases your clients view you as less than a defense attorney. People, I remember I had people saying, when you become a lawyer, I'm going to hire you, kind of thing. And I said, well, I'm already, anyway. But you learn what goes into representing somebody, and there's a lot of tension and there's a lot of distrust that is part and parcel of that relationship, especially if you're a public defender and it's kind of a shotgun marriage. You're forced to this guy's forced to have you as a lawyer, and there's a lot of times there's not a lot of healthy communication. Not always, but many times the biggest problem I have is explaining to a defendant, he's your lawyer. You're mad because he's not telling you what you want to hear, but he's telling you what you need to hear. He's not supposed to be your friend. He's supposed to tell you what he thinks your best choices are, and then you make your mind up. And I understand that. So lawyers sometimes, they need resets because they're having problems with they're having client problems, or they're having to run around and check some other things out and think. I'm a lot more amenable to that because I've been through that. I know what happens when you're trying to put a case together for somebody who may not be cooperating with you. So I'll give them some time to get that done. I think it's important that they're ready, and at some point you get to the point where you realize that nothing's going to change, and you have to push things forward. But I'm aware of the dynamic, and so I tend to give lawyers, defense attorneys, the opportunity to represent. As I said, I give you a chance to build your case, and sometimes that takes a while. But also, and when I was a prosecutor, I did this. I always viewed or evaluated my cases as if I was a defense attorney, because I wanted to look for the problems. So, what problems do I have here? Can I prove this? What would a defense attorney argue about these particular facts? Can I prove this particular element of the offense? And I would sit down there and just critique my case as if I was a defense attorney. And I thought it made my cases stronger. It at least made me prepared in court if I thought something came up. If something came up, I was prepared to address it if the defense attorney raised it as the issue. So those things are invaluable. They're invaluable. And I understand the defense process. And I don't get mad at a defense attorney when, oh, Judge, I need to get an investigator for this purpose, or, my client has told me about this at the last minute. I don't feel like I'm ready to go to trial. And I can get mad at him and say, why didn't you do all this like I've seen other judges do? Believe me, I had Judge McCarty, my first judge when I was a public defender, who was called Smokin' Joe. And he would scream at you all the time. He was always screaming at you. But you knew if you waited long enough, he would eventually do what you asked him to do. But you had to put up with the screaming. So I didn't want to be that person. I wanted to so I have to be firm sometimes and tell them no, but I do it in a way that's not demeaning, because I've seen people get, I've seen it being a bully situation. I hate that. But being a defense attorney, being a public defender, all those things help me going forward in understanding what the other side is doing and giving and respecting what they do, and also making sure that I don't overreact to something as a judge and make people think I'm being unfair, because that's the last thing you want to do is appear to be unfair.
I love that response. I have a classmate. She's retired now, Judge Gwen Rooks.
I know Gwen Rooks very well, yes, sir.
One of her favorite lines were, be careful what you ask for in court. Those who come in shouting, "I want justice," and she would respond, "Justice is what you deserve. Mercy may be what you are really asking
Right,
for."
right.
Give me your comments on that.
I used to be I was a prosecutor in front of Joe Brown for a while, Judge Joe Brown. And he was famous for people who come in and ask for probation. And he would give them probation. And boy, he would give them probation. And they would turn around and say, "Well, Judge, I've decided I just want to do my time." He goes, "Oh, no, 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 no. You're on probation." And it would be, he would bring them in about every 6 months or 6 weeks, and they would have this day, he would talk to them for a day, for several hours. He would bring him in and talk to them. But I agree with you. I mean, the thing is, and again, part of it is to look, and again, some folks, especially people who've been through the system a few times, they think they know everything, that they think they're smarter than you. They think that they can get away with things. They think a lot of them are very glib and very, they think they can talk their way out of things. And when you start talking about, okay, what is justice? You're balancing what their thoughts are with the victim and with the law. And like you say, sometimes justice is going to look completely different when you take all those things into consideration. My experience with some of these people who come in and say, "Oh, they're asking for the moon," they know good and well they're not going to get it. They're just going to ask for it. But I think Judge Rooks was correct in that standpoint. Is justice is justice. And I've had people ask me for forgiveness and things like that, and I say that's not my place. The victim's family's here. You can ask them for forgiveness. I'm not here to forgive. I'm here to determine what the proper punishment should be. And I think that proper punishment, again, which is what y'all draft, is what I'm trying to impose and make sure that what I impose is, in fact, the proper result in the case.
And Mr. Chairman, I only have a couple of more. I would have had more, but my colleague who sits behind the lawyer asked a couple of those questions. I appreciate that. When you're looking at your ultimate goal, when you're sitting on that bench, are you looking to deliver justice in the form of retribution or restoration?
Both, maybe. Depends on the circumstances.
Well, I'll give you a third one, reformation. So I'll give you all three.
Okay. Again, it kind of depends on what you're looking at. When I'm dealing with, a lot of these folks I'm dealing with have horrible drug problems. And, I would love for them to be able to rehabilitate themselves, because what's the goal? What's our goal? Our goal is to stop recidivism. Our goal is to have these people, if they come through the system, they don't come back. That's the goal. And that's our goal across the board, try to keep these people from coming back. And so we address the problems that got them in front of us in the first place. So you have rehabilitation is a big part of what I do. You also have a situation where you have a mental health component in a lot of these cases, and that's something that doesn't get addressed enough. We have a big hole in our system for people who are mentally ill. There's limited resources. And, you talk about rehabilitate, restore them back to some kind of productive situation. That becomes really difficult when you have limited resources and someone who is a drug addict and they're also mentally ill and they're probably related, they're self-medicating. That's frustrating for the court. And, even though we get put in that social worker mold sometimes, I think over the years we've kind of gotten that role, even though I think we're not really well suited for it. We have to look for alternatives. We have to look for ways to solve those problems. But then you have individuals who commit a crime that is so violent or so heinous, and you talk about retribution. Yeah, you want to put them in a situation where maybe they'll never come out in the public again, which I've had to do a few times. I had a guy that was a child rapist. He got convicted of child rape. He had 6 prior convictions for it. He had gotten out of prison after 17 years and did it again. So I gave him 90 years because that's what the law said I could give him. I couldn't give him more than that. I could only give him 90 years. But I wanted to make sure that he did not ever come back into the society again because I knew he was going to reoffend. So you have, and that's why I think it's so important the way that the laws are set up, and you all have set them up, it's individualized. And so you approach that from the standpoint that this person needs X, this person needs Y, this person needs Z, and I have the ability to do that based on the law, following the law that you've set out for me. So I hope that answered your question, but that's the best way I think I can do it.
Well, you got to most of it, and I'm looking forward to taking you on the road.
Okay.
So I'll leave the rest of that.
Okay, that's fine.
But the last one I want to ask about, Mr. Chairman, is about blended sentencing. You spoke to the need for more counselors and more resources for those with mental illness. What about our young folks who are thrown into an adult criminal justice system because their crime may have been so horrid and that the juvenile system says we don't have time, and not that we don't have time, but there's not enough time before they become adults,
Right.
and are out of our custody to really rehab them, to create some real behavioral modification. What's your opinion on blended sentencing? Would that be helpful in
it could be
the justice system?
It could be depending on, and again, I think it depends on the individual, and that's something that's going to have to be assessed. Like right now, when we do a sentencing, and y'all have ordered through statute that the Department of Correction put together what they call the strong R assessment. We get a risk assessment with every sentencing, so we can tell what these people's problems are, what their background was as far as criminality or education or home issues or mental health issues or things like that. And it really gives us a good idea of who we're dealing with. So you'd have to do some kind of an assessment. And the trick to any type of thing when you talk about blended sentencing is making sure you pick the right person is being put in that situation, because otherwise you don't want failure, because people will look at the failure and say, this is terrible, we don't want to do it. And it will cause you to possibly sacrifice a program that may work for some. But here's the thing I wanted to mention is that, and again, with juveniles, and I've told this to the governor and people like that, we're talking about what do we do about, the criminal justice system and justice reform. It makes a lot more sense sometimes to put money on the front end than on the back end. If you can keep kids from coming in the system, you don't have to worry about it. And I'm talking 8, 9, and 10-year-olds. I've seen 12-year-olds who are hardened gang members, and you can't do anything with them. I mean, we can try. We had a 15 or 16-year-old I had in front of me on an armed robbery. He wound up getting murdered. He was murdered while he was on bond and again, I don't know what the circumstances were. But when I was talking to the folks, we were dismissing the case on him, he was a suspect in 4 homicides. He was 16 years old. I mean, we have some really hardened criminals at 15 and 16 years old. And the juvenile court system, I don't think was really set up for that type of criminality, but we're dealing with it. And those people will get transferred. And I had a 17-year-old I sentenced to 8 years recently for aggravated robbery. If I had been sentenced to 8 years at 17, I would have been a lunatic. I would have been crying, screaming. He never had any emotion whatsoever. It just didn't affect him. We got to keep these kids from getting into the situation in the first place. We just have to. Otherwise, as I was told a number of ministers in Memphis that when they get to me, something bad has already happened. And it's awfully hard to unring that bell once it's been rung. And you hate to see them come back. And I talk to them all the time. I said, young man, you've got this opportunity, but if you don't do what you're supposed to do on probation, whatever it is, you're just going to become a fixture here. There are people, I know their names. I recognize their names. They come back through all the time. And, blended sentencing makes sense if it's targeted, but it makes a lot more sense to try to do everything we can to keep them out of the system in the first place. And mentoring is a huge thing about that, because a lot of these kids don't have anybody that can really give them good life advice. I mean, it's frightening.
Thank you very much. I appreciate you being frank, honest, just being completely open with us. And I'm looking forward to following your career.
Thank you, sir.
Thank you, Mr. Chairman.
Thank you, Representative Hardaway, and thank you, sir, for your responses. Next on the list, I do have Representative Lamar. You recognized?
Thank you, Mr. Chairman. Excuse me. Do you think the criminal justice system in Shelby County in the state of Tennessee is set up where it makes it easier for people not to reenter the criminal justice system? And if you don't, what are some of the things that we can improve on?
And I think it depends on the thing that's strange about Tennessee. If you look at the statistics, and this part people have a hard time putting their head around. West Tennessee has less recidivism than Middle or East, and you think it's just the opposite because you think, oh, Memphis. Our recidivism rate is actually less than Middle and East Tennessee. I think part of that is because of methamphetamine. I think meth defendants that I deal with are more likely to reoffend. They just are. They do a lot of thefts. I mean, a lot of my auto burglars are meth heads, and they'll do 25 in a night. I mean, when they get arrested, they've got 40 cases because they do so many of them. And it's really hard to break that. For some reason, the methamphetamine is a problem. West Tennessee has a lot of resources when it comes to addiction issues. We have places we can put people for treatment. There's a lot of counties in Tennessee that don't have resources. When we were on, I was on the Governor Lee's Criminal Justice Reinvestment Task Force 2 years ago. Some of y'all were on that also. One of the things we identified was that we were lacking in resources for treatment, and that was mental health and drug treatment. And if we could put money in those things, that maybe we would keep people out of going to prison in the first place. They get into a program and maybe would never come back in. Once somebody goes into prison, it makes it, I think, more likely they're going to reoffend. I just think that that's a step that I think they get around a lot of criminals, and they're with criminals 24/7, and I think it does have an impact on their chances of breaking out of that cycle. But if you have an opportunity to put them in a program early on where they can get drug treatment or they can get mental health treatment, they can address that problem. Maybe they won't be back committing criminal offenses. That's really about the only thing I can think of, because there's a lot of things out there that none of us have control over. The family structure. So many of these people we deal with have no family structure. They're basically cut loose. I heard there was a statistic in Memphis where there was 20,000 young men between the ages of 15 and 25 that were not in school and not working. That is your population that you're dealing with. I deal with a lot of mental health issues. Shelby County Jail a year or two ago was the largest mental hospital in the state. I mean, these are serious problems, and the criminal justice system has now been tasked to deal with this, and we're really not set up for it, but we're trying the best we can. But resources are huge. Morgan County, that was set up as a kind of a satellite or regional treatment facility, is a fantastic idea. We need to have more of them around the state to give people an option to get people out of their county. It really helps with drug treatment when they're not around the same people all the time that they've been doing drugs with. So it's a huge deal to move people away from their counties. Those things are really important. And again, we were going to recommend that, then the pandemic hit and the money became a problem, so it really didn't get anywhere. But it's definitely, when you start talking about reform issues, we actually have a pretty good framework in Tennessee. It's just not funded. Mm-hmm.
Representative Lamar, you recognized.
Thank you, Mr. Chairman. My last question is, Tennessee used to have, for first-degree murder, it's 51 to life with the possibility of parole without.
Well, it still is. It's 51 right now.
Right. Mm-hmm. Years ago, it used to be 25.
Right.
It was up to 51 because, unfortunately, the Democrats on the federal level, the crime bill, which much research has shown how much it has played a negative impact on the criminal justice system. Do you think that it will have a negative impact to change one of those, the possibility of parole to 25 years back to original standing, given that Tennessee has one of the largest sentencing around this particular crime in the country?
Well, let me just say this. In my 40 years, life went from 30 calendar years to 25 calendar years to 51 calendar years. Before that, in the 60s, life was actually 12 years. That's why everybody got 99 years. The prosecution would ask the jury. It was jury sentencing. They wanted 99 years, which you had to do 25 to get paroled on 99. Here's the problem that I have, and again, this is strictly y'all's call, but I can't tell you how many families I sat down with as a prosecutor when we were talking about one of their family members was murdered, and maybe we're looking at the death penalty, and we said, look, he'll take life. Life is 51 years. And the family said, that's fine, we agree with that. You don't want to have to come back 10 years later and said, yeah, it's going to be 25 now. It's not really a contract necessarily, but you've told folks this is what's going to happen because here's what the law is. Now, I used to always say, it's still up to the legislature. But I said, this is what it is now. It's 51 years. And there were people that quite possibly would have, the state would have sought the death penalty on if the family was really pushing the issue. I never really made the family never made me. I never let the family make me make that decision. But if you're on the fence about something, the family says, we really want this, then, sure, you're going to go for it. But that gave you an option where, yeah, it's a lot of time. But murder, and I'll tell you, we have so many senseless killings in Memphis, it's ridiculous. And, the fact that someone is going to be locked up for the rest of their life for doing something really, really horrible, I never had a problem with that when I was a prosecutor. And last month I sentenced a guy to life. He got mad at some guy, creeped up to him while he was parked in a car and shot him 4 times in the back of the head through the window, okay? Just executed him. I have no problem sentencing him to 51 years. That's what it was. The state wasn't asking for life or life without parole, so I sentenced him to life. And, those cases, golly, I've seen some horrible things. And the fact that we're not sentencing people to death in Tennessee, Shelby County used to be, everybody goes to get the death penalty. I have not had a death penalty case in 10 years or 9 years as a judge, and quite frankly, I can't think of a death penalty case that we've tried in Shelby County since I got on the bench because life meant 51 years. So there's a side to it that people don't think about. We haven't been putting people on death row. There's the other side, though, is the families have gotten some satisfaction in knowing that this person is going to be punished. My child is in the ground for the rest of my life and everybody else's life. This person should also be away from the public for the rest of his life. And I think that, I think that some people think, well, gosh, that's a lot of time. But, murder is murder. Murder is forever. So, I just feel strongly that before anybody really goes down that road, to kind of think clearly about, what we've already done and what we've already told people, and be prepared, if it does happen, to answer those people, why? Why are you doing this? Anyway, that's the only advice I can give you.
Thank you, Judge. Thank you, Representative Lamar. Members, that has exhausted our list, and we will go now back into session. Thank you very much for your comments, sir.
Thank you.
We are back in session, and while we were out, I had an indication from our Vice Chairman that he wished to be recognized, and so Vice Chairman Sexton, you are recognized.
Thank you, Mr. Chairman. Mr. Chairman, I would like to make the nomination of Judge John Campbell, Sr. to the Court of Criminal Appeals.
Members, you've heard the motion. It was properly seconded. Any discussion of that? Seeing none, we are ready to vote. All those in favor of a positive recommendation for Judge Campbell, please signify by saying aye.
Aye.
Those opposed? The ayes have it, sir. Congratulations. Thank you for being here today. Thank you for your time you spent with this committee.
Thank you.
Yes, sir. Members, we do have one bill before us, and that will take us to our calendar. It is item number 1, the only item, House Bill 1640 by Vice Chairman Ogles. Vice Chairman Ogles, you are recognized. Sir, you have a motion and a second. You're properly recognized before the committee.
Thank you, Chairman, members of the committee, and I'm glad that Judge Campbell wore y'all down quite a bit. Hopefully this will be brief. Bill
Summer
16,
study.
Bill 1640, as presented, will remove rape from the list of offenses that are eligible for probation. As Judge Campbell said, there's certain things that require justice and the proper punishment I believe rape is one of those offenses that should not be probated. Some data from the healthresearchfoundation.org says that 60% of those on community supervision will reoffend who have been given community supervision for rape. There's also some data from Dr. Fobert out of Union University that did some research of 12,600 male students in our colleges. Of those, there were roughly 2,071 sexual assaults, and of those 950 assaults, 46% of those, so let me clarify, 46% of those that were convicted of sexual assault self-reported that they had committed that act 10 or more times. So many times our rapists are not just rapists, they're serial rapists. So I think it's very pertinent that we remove them from the general population and they serve the entirety of their sentence. With that, I will take any questions. Chairman, thank you.
Thank you, Mr. Sponsor. And I do have a list, a couple of folks who've got some questions for you. First up, I have Representative Dixie. You're recognized, sir.
Thank you, Chairman. Quick question. What are some of the other offenses that are not eligible for probation?
Vice Chairman Ogles.
Thank you, Chairman. We may have to go out of session for that. I would think most of those are murder-related, but we will have to clarify that with legal, if that's okay, Chairman.
Members, I believe we do have a question for legal, so we will go out of session. And Ms. Fogarty.
Michelle Fogarty, Legal Services. Currently, probation defendants are not eligible for probation for vehicular homicide by intoxication, aggravated kidnapping, aggravated robbery, aggravated sexual battery, statutory rape by an authority figure, aggravated child abuse or neglect, a Class 1 controlled substance of a certain amount, sexual exploitation of children, aggravated sexual exploitation of children, and especially aggravated sexual exploitation of children.
Any further questions? Okay, thank you. Members, any other questions for legal services while we're out of session? Seeing none, we are back in session. Representative Dixie, does that exhaust your question?
Yes, thank you.
Thank you, sir. Next on my list, I have Representative Lamar. You're recognized.
Thank you, Mr. Chairman. Hey, is this aggravated rape or just rape, period?
Vice Chairman Ogles.
Thank you, Chairman. As written, I believe it is just rape, period, not especially aggravated rape.
Representative Lamar.
Thank you. Say someone could be going through a case where they're being accused of rape. What if they're actually being falsely accused? Would they not be eligible for probation?
Vice Chairman Ogles.
Thank you, Chairman. Well, my hope would be if they were falsely accused, they would be, the judge or the jury would see that they were innocent, and that would never be a circumstance that we would have to deal with. I have great trust in the judiciary process, and hopefully those that are convicted of rape, not hopefully, we also always want that to be the case, that they have indeed committed that crime. But thank you for that question.
Thank you. That's it, Mr. Chairman.
Thank you, Representative Lamar. Seeing no further questions, we will entertain a vote. All those in favor of sending House Bill 640 to Finance, Ways, excuse me, I think I misspoke. House Bill 1640 by Vice Chairman Ogles to send it on to Finance. All those signify by saying aye. Aye. Those opposed? Sir, you head to Finance. Thank you very much.
Thank you, Chairman. Thank you, committee.
Members, that exhausts our calendar for today. If there's no other business before this committee, we are adjourned.